I recently decided to do a side-by-side comparison of the best trust jurisdictions within the United States. And when I did that original video that looked at the overall picture of best trust jurisdictions, we looked at Wyoming, South Dakota, Nevada, Alaska, and Delaware. So these are really known as the five best trust jurisdictions. Some of those for actual good reason, and then some of those not for good reason. So they actually shouldn't be considered in the top five. But when I was going through that list in that video of top jurisdictions, we looked at the entire spectrum. Now I'm going to focus on more specific aspects that are important to the makeup of a strong trust jurisdiction. So we're going to look at domestic asset protection trust. So let's get started. So I'm going to share my screen with you. I want you to be able to see this chart that I'm looking at. And so throughout these videos, when I'm talking about trust jurisdictions and doing a side-by-side comparison analysis, I find that it's useful if you can look at, other people's work who've put together an analysis of all of these things that make up these really strong trust jurisdictions. So there is this attorney in Las Vegas named Steve Ocean. Steve is known for being a very, very capable asset protection trust attorney. He focuses on Nevada trust planning, and he's done a great job of really marketing Nevada, as well as with the other attorneys and trust companies there, on why Nevada is a really great jurisdiction. I believe his father started the law firm, and he himself was an asset protection attorney and did a lot of work in that space. And so they have a long history of working in different jurisdictions and comparing the different jurisdictions. So he comes out with what's called, he calls his annual domestic asset protection trust state rankings chart. And I don't know if he actually comes out with it every single year, but this is the most recent one, the 11th annual, and you can find it at his website at oceans.com, and we'll include that website link in the about section in the comments. So it's oshins.com, but we will include that. So as you can see here, just taking a quick look, we have 15, 16, 17, 18, 19 states that are listed on this chart. So there are 19 states at the time of this chart that have domestic asset protection trust laws. And what does that mean? It means that you yourself can set up an irrevocable trust for your own benefit. Move out your own assets into that trust, and therefore those assets be protected from lawsuits, creditor claims, divorcing spouses, etc. Not every state allows someone to be able to do that. Historically, you had to rely on someone else to set up an irrevocable trust for your benefit, usually move an inheritance into that trust. When usually your parents passed away, they'd leave it to the kids, but they'd leave it in trust. But now we have this opportunity to set up a trust for our own benefit for purposes of protecting our assets. So I have videos about how those trusts are actually structured, but we want to focus on what makes a good asset protection trust jurisdiction. We see here Nevada is number one. We see that South Dakota is number two. When we go through this, you're going to learn that there's almost no difference whatsoever between Nevada and South Dakota. And then I'm going to talk about a few things that aren't actually listed on this chart that I think actually push South Dakota above Nevada. We have Ohio at 3. A lot of people aren't familiar with Ohio as a strong trust jurisdiction. They've made great strides in last probably 5 to 10 years, and they have really strong asset protection trust laws. We have Missouri, Connecticut, Delaware, and Tennessee. A lot of people think Delaware is the best trust jurisdiction, and it really isn't. At one point, maybe it probably was, but they haven't continued to update their trust laws like other states have. Same thing goes for Alaska here at number 8. Alaska was on the forefront of updating trust laws, 20, 30, 40 years ago, but they've really fallen behind since then. I'm going to keep scrolling down here, and we see at number 12, Wyoming. So Wyoming, again, has a really great reputation, and it's not really deserved. So we can go into reasons why here. We'll scroll down, see if there's any other states that we really want to talk about. And there probably isn't. But we'll scroll back here to the top and we'll start going through the details. So we'll start with, maybe I won't hit all of these things in as much detail as others, but I think, one of the big things is the statute of limitations for future creditors. So, there's this balancing act between when a person can actually move assets to the trust without defrauding a creditor. And so, what is that statute of limitations for a future creditor, right? So, let's say you move assets in to a trust and then later you end up having a personal creditor claim against you. What a creditor can do to challenge these assets is bring a claim that you have fraudulently conveyed assets to that trust for purposes of defrauding that creditor. So a future creditor has 2 years to bring a suit against you to say, hey, they fraudulently conveyed these assets to the trust for purposes of avoiding this personal creditor claim against them. Okay, I said 2 years. It's 2 years for Nevada. It's 2 years for South Dakota. You see, Ohio has 1.5 years. 1.5 years is the shortest statute of limitations that you're going to see. Other states have 4 years, 2 years. I'm going to scroll down here to Delaware. Delaware has 4 years. So that's one of the reasons it's not ranked higher. Similar with, I think Wyoming has 4 years as well. You can see that here. So 4 years for a future creditor. So that's kind of a long, lengthy statute of limitations window that somebody can challenge any transfers. It's not as simple as just having the statute of limitations for someone who has a creditor claim against you, though. They have to actually prove something. So next, statute of limitations for a pre-existing creditor. So if you already have a pre-existing creditor, you still have the ability to do asset protection trust planning. Similar to, Nevada and South Dakota, similar, 2 years. Or if the pre-existing creditor actually has notice, if you give them notice, they only have 6 months, a half a year to actually bring, once they discover it, to bring a suit against you claiming that there was a fraudulent conveyance. I won't go back through all of these again, but we do see Delaware 4 years. That's pretty lengthy. Or 1 year if you do give the creditor notice. Alaska, 4 years or 1 year, and then Wyoming, same thing, 4 years or 1 year. That's just not really advantageous when you have options out there like 2 years or maybe even 1.5 years. So this is really interesting as well. This next column here, let's see if I can highlight just it. So spouse/child support exception creditors. So what does this mean? Exception creditors. So some state laws will say that if there is a creditor claim against you, then in some instances, we will honor that creditor who has that claim. And that's what an exception creditor is. So Nevada is very, very strong in this and say there's no exception creditors. We're not going to honor a divorcing spouse or a divorced spouse, alimony or child support whatsoever if you've moved your assets into trust. I personally have a problem with that because if you do have an existing divorced spouse claim or alimony or child support, I think it's just good public policy that you are responsible for that. But that's probably a video for a different time. South Dakota, what do they say? They say that at the time, they do have exception creditors, but what they say is that only at the time of the transfer, if you are indebted to a personal creditor, whether it's a divorcing spouse or alimony or child support, will you still be on the hook for having to pay that? But if you aren't subject to any kind of personal creditor claim because of divorce, alimony, or child support when you transfer those assets in, then you don't have a problem. Or if you get divorced after the fact or have these outstanding obligations after you set up the trust, then there's no problem. So in most people's instances, in fact, everyone I've ever set up a South Dakota asset protection trust for, they've never had this issue. We've never had to be worried about this. But, I guess if you did, then you would want to consider Nevada. But again, I personally don't want to set up those kind of trusts for someone. Going down here to Delaware, they have exception creditors. So divorcing spouse, alimony, child support. So someone, regardless of when the personal creditor claim exists related to those items is going to be able to pierce that trust. Similar with Tennessee, similar with Alaska, they have a divorcing spouse as exception creditor. And then we'll keep going here. Wyoming, same thing, child support as an exception creditor. New Hampshire is in number 11. I haven't really talked about them, but they do have strong trust laws as well. But they do have all three: divorcing spouse, alimony, child support as an exception creditor. Okay, so the next column here, pre-existing torts exception creditors. So if you have some type of other pre-existing creditor, not related to a divorce, alimony, or child support, or those other pre-existing tort exceptions, an exception creditor, could they pierce your trust? Nevada, no. South Dakota, no. Ohio, no. So there's no exception creditors there whatsoever. So when it comes down to it, it really is South Dakota and Nevada that are the only two states that, depending on your situation, have no exception creditors whatsoever. Down here, Delaware, if there are pre-existing torts, then they can pierce the trust. Tennessee, no pre-existing exception creditors. Same with Alaska. Let's see with Wyoming. So Wyoming does have exception creditors. Property listed on application to obtain credit can be subject to creditor claims. They can pierce that trust. Okay, so this next column here, ease of use, new affidavit of solvency required for every new transfer. So what is that even talking about? So anytime that you are transferring assets into a trust, you're going to have to either fill out a new affidavit of solvency, or you're not going to have to. So what is the affidavit of solvency? So it basically says that, one, you're not insolvent, and making these transfers to your asset protection trust is not going to make you insolvent. So some states require you to only have to do one affidavit when you're doing the trust initially, when you're funding the trust initially, and then any subsequent transfer of assets after that initial transfer, you're not having to do a new affidavit every single time. So as you see here, Nevada and South Dakota, you don't have to do a new affidavit every time you move assets into it. Ohio, this is kind of why they're in a distant third place. They do require an affidavit with a few exceptions. Delaware, no affidavit required. That's good. However, Tennessee and Alaska, affidavit is required. That's not advantageous. That doesn't make it easy to really do this. It's additional paperwork. It's additional administrative work. Same thing with Wyoming. They do require an affidavit every time that you make a new transfer to your asset protection trust. Fraudulent transfer standard. That's the next aspect that Steve Oceans looks at when he's trying to figure out who has the most advantageous domestic asset protection trust laws. And as you see here, it is pretty uniform. So there's not a lot of variation here. As you see, it's clear and convincing evidence. It's not beyond a shadow of a doubt. It's mostly clear and convincing evidence. So they do have to prove that there is some type of fraudulent conveyance. So going back to that idea of the statute of limitations, just because you made a transfer during a certain period of time during that statute of limitations window doesn't mean that it's a fraudulent conveyance. There has to be something proved by the person or party that has a creditor claim against you, that they have clear and convincing evidence that you indeed made this transfer for purposes of defrauding them and avoiding this particular outstanding claim against you. So clear and convincing, it doesn't have to be beyond a shadow of a doubt. So that's just something to keep in mind. Okay, so we're getting close here to the end. So decanting state ranking. So we're going to go over decanting jurisdictions at some point, and Steve Oceans actually puts together an annual decanting ranking chart as well. We'll get into that at some other date. But the idea behind decanting is moving assets from one irrevocable trust to another irrevocable trust. And that's usually done through the trust protector. We'll have a video on trust protector laws as well. But if there's some reason that there's a change in circumstances or change in debtor creditor laws or tax laws or anything really, whether it's personal circumstance or changes in law, you can move assets from one existing trust to another trust. So often you might have an old trust that just doesn't really work for you anymore, and you want to move those assets to a new trust that you set up in South Dakota. Let's say, you live in Texas where I live, you set up a trust 20, 30 years ago, and it doesn't really work anymore. Well, you figure out South Dakota is a more advantageous jurisdiction. You set up a trust in South Dakota. You could move those assets, decant those assets in the Texas trust to the South Dakota trust and streamline your administration process. So that's something to keep in mind. Different states have different laws around when you can decant or move those assets to a different trust. South Dakota, you see here, ranked number 1, Nevada ranked number 2. South Dakota has very few limitations on when you can actually move those assets to a new trust. Nevada has some limitations, and then you'll see these other states, they have greater limitations. Delaware is ranked number 3, Tennessee 4, Alaska is ranked number 8, and then we'll get down here to Wyoming. Again, they're ranked 13. As we see, Wyoming's just not really as strong of a trust jurisdiction as a lot of people think. It has an overall rating out of 100, a 78. And so that's this last column here, total score. Nevada has a 99, 99. South Dakota has 98. Delaware 83.5, Tennessee 83.5, Alaska 82.5, and like I said, Wyoming 78. So focusing on Nevada and South Dakota because they are by far, even as you can see here in this, just based off the domestic asset protection trust rankings, Ohio's in a distant third. As I said earlier, they have an overall score of 85, whereas Nevada has a 99, South Dakota has 98. What's really separating these two here is the possibility of a exception creditor when it comes to divorcing spouse, alimony, or child support. But again, if you don't have that when you set up your trust, then South Dakota and Nevada are the same when it comes to this. And then the state decanting is the last difference there. So they're very, very close. The one thing that's not on this trust that I think should be on this trust is related to privacy laws. So let's just say that there's some type of lawsuit or some type of court proceeding that involving your trust, and details about your trust come out during that proceeding. South Dakota has a law, a privacy law that says that any of those details that come out related to your trust are automatically sealed from public eye, and that seal is perpetual. So it exists forever. So those details are never going to come out. As opposed to Nevada, it is purely up to the judge's discretion. So you are taking a bit of a chance there, and you're gambling a little bit with that privacy aspect. And I just think that is, again, as I've said in other videos, if you're taking the time to look at the states that are most advantageous, then go with the one that is most advantageous. Don't settle if there's a better option out there. So I think that privacy aspect really pushes South Dakota above Nevada, but it's not addressed here. So one thing that I will encourage you to look at, and I mentioned this in my first video about overall rankings regarding trust jurisdictions. I had started looking at Bridgeford Trust Company's website and how they have rankings here. Bridgeford has, they're not endorsing my videos or anything like that. I like this chart a lot. And the reason I like it is because they provide citations, and that's unique compared to other trust companies that have similar charts. And we'll include this in the About section so you have access to it. But one of the reasons that I like this chart is because it has a citation, the second citation here, to an article that was released 2 years ago. And to my knowledge, this is still the most comprehensive piece of literature out there that talks about the best trust jurisdictions. And so go to that. take a look at this article that was in wealthmanagement.com, Trust and Estates publication, leading publication in the trust and estates world. And it talks about very comprehensive issues related to the best trust jurisdictions. So we'll include that so you can take a look at it. And it will talk about things like privacy, rule against perpetuities, dynasty trusts. And I'm going to have more videos about that. But just don't miss this opportunity to take a look at that. It's a pretty lengthy article, but it's very, very comprehensive in its analysis.